O1, O2. The O non-immigrant classification is reserved for individuals who have extraordinary ability in the sciences, arts, education, business, or athletics, which has been demonstrated by sustained national or international acclaim, and their essential support staff and qualifying dependents. Unlike the EB1 immigrant category, which relies on similar eligibility requirements, the O visas are non-immigrant or temporary in nature. The O classification is divided into the following categories. 1. O1A for individuals with an extraordinary ability in the sciences, education, business, or athletics. 2. O1B for individuals with an extraordinary ability in the arts or extraordinary achievement in the motion picture or television industry. 3. O2 for primary assistant or essential support personnel 201. And 4. O3 for spouse and children of O1s and O2s, who is eligible for the O1 visa. The O1A/B classification is a work visa category that allows dual intent in the same way that H1Bs and L1s are known for, and may provide an alternate path towards working and living with family in the United States. The individual must be seeking to enter the United States for purposes of continuing the type of work in which he or she excels. Both the O1 and O2 visas require sponsorship from a U.S. employer or agent. So, a U.S. employer or agent must file a non-immigrant petition with United States Citizenship and Immigration Services on their behalf. A U.S. employer can petition for many different types of individuals with extraordinary ability for employment. In the field of art, extraordinary ability means a high level of achievement in the field of arts, evidenced by a degree of skill and recognition substantially above that encountered. In this area, the petitioner must prove that the artist is prominent in his or her field of endeavor. Also, the O1 visa can work for a variety of professionals, from business executives to chefs to doctors. The question becomes, how does one demonstrate to USCIS that the individual does indeed have extraordinary ability in a profession? There must be evidence that the beneficiary has received a major, internationally recognized award, such as a Nobel Prize, or evidence of at least 3 of the following items. Published material in professional or major trade publications. Published material in professional or major trade publications, newspapers, or other major media about the beneficiary and the beneficiary's work in the field for which classification is sought. Original scientific, scholarly, or business-related contributions of major significance in the field. Authorship of scholarly articles in professional journals or other major media in the field for which classification is sought. A high salary or other remuneration for services, as evidenced by contracts or other reliable evidence. Other comparable evidence must be submitted to USCIS to meet the requirements. The evidence required for artists focuses more heavily on performances, roles, publicity, and pay, among other considerations. Applicants should keep in mind that O1 petition application can be premium processed with USCIS, which calls for adjudication of the petition within 15 calendar days after being filed with the agency. For how long is this visa valid? Approved visas are valid for an initial period of up to 3 years and extended at 1-year increments with no upper limit, by demonstrating that the beneficiary will continue to be needed by the U.S. employer for carrying out the duties for which the individual was initially admitted. What 3 types of documents are needed for the O visa? In order to make a strong petition for an O1 visa, the required documentation is 1. Consultation. 2. Contract. 3. Itineraries. Let's explore each document. Consultation. It involves a written opinion from a contemporary group, which may include labor organizations with competence in the applicant's area of expertise. A consultation will not be required in the following instances. 1. If a peer group or a labor organization with expertise in the area of the beneficiary's ability does not exist. 2. If the beneficiary alien is only seeking a readmission to the United States within 2 years from previous consultation to perform the same services, contract. The contract between the petitioner and the beneficiary must be submitted. If the agreement is oral, a summary of the terms of oral agreement may be filed together with the petition form, such as emails and other forms of proof. Itineraries will lay down the travel plan, schedule, agenda, timetable, and other programs included in the beneficiary's travel within the period of stay in the United States. Let's compare this visa with other visa options.